Martinez.
All right, so we're on the record in docket 2501405. That is people of the state of Michigan versus Richard Martinez. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
And sir, you are Richard Martinez, is that correct?
Honor.
Thank you.
And I apologize if I'm dressed. I torso ligaments in my knee.
No worries, no worries. This is the time set for a pretrial in the matter, a state of Michigan pretrial. Mrs. L, how are we proceeding?
Your Honor, this case is a dog at large. Mr. Martinez's dog escaped his fence by digging underneath it. Mr. Martinez came in today and explained that he did fix that fence, and we believe it was fixed in a manner that will prevent the dog from escaping again. At this time, we would ask for this case to be dismissed for compliance.
All right, compliance purposes, and this is for Liam, right? Okay. All right. So based on compliance and request, we'll dismiss it without prejudice. It is on a ticket, so a nollie process is not needed.
Steer me like that.
And you should all be all set, Mr. Martinez.
Right.
Okay. Anything else for the record in 2501405, Mrs. L?
For the people, thank you.
You're all set, sir. Ms. Wicks, how are you?
I'm well. How are you, Judge?
Pretty good. And I just let in Mr. Harris.
I believe he's going to speak to Ms. Rogers.
All right.
I am ready, I believe, on basically the rest of the 30 docket.
All right.
We can go ahead with Juanita Jones then.
Ms. Jones. All right, let's do the contempt hearing first, and then we'll do the final pretrial. So I have two contempt hearings. I have 19-04767 and 20-03514. That is people of the state of Michigan versus Juanita Jones. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, filling in for the Attorney of Record, Georgia Mead, on behalf of Ms. Jones, who is present, standing to my right.
And ma'am, you are Juanita Jones, is that correct? All right, thank you. This is the time set for a contempt hearing on these two files. Mrs. L, how are we proceeding?
Your Honor, I believe at this time we would be asking for the contempt hearings to actually be adjourned with the underlying cases for discovery purposes. We seem to be missing a lot of the evidence from both of these files. We believe that would help in the contempt hearings as well. That's my understanding. I will defer to Ms. Wicks as well.
Ms. Wicks.
Thank you. That is correct, Your Honor. Mr. Anid did leave me notes that he has, in one file, he has only one page of an actual police report of substance, while there are about 20 remaining pages. He opines that it is not substantive or helpful, and that we are missing dash cam, as it, I believe, at least the 2020 file would be a MSP. So it would be dash cam, it would not be body cam. On the 2019 file, that I believe would be an LPD officer, and we still have no body cam in that file. So we would be asking for this to be reset to allow us to get that discovery.
So that would be the discovery on both of those. They're old cases. There's 1, 9, and 20. And we've got some, let's see. We have a failed to appear out of January of 20. The allegation here is that Scram Tether was removed. And then oh, positive, that's correct. And then on the 20 case, it's just been set for final pretrial. It was arraigned on June 2025. All right, so so for discovery issues on both those. We'll reset those files. Did you want to reset it for final pretrial?
Yes, I think that would be beneficial.
All right. So discovery issues on 1904767 and 20-03514, and we'll reset for final pretrial.
26 at 8:30.
All right, we'll reset those for August 26th at 8:30 on both those files. That's the 20-03514 and the 1904767. They're both older files. I think the bond violation must come out of the pretrial conditions. Is that a fair statement, Mrs. L and Ms. Wicks?
I believe that would be correct.
Yes, Your Honor.
Yeah, there were bond conditions. Ms. Jones, you gotta stay off alcohol, okay? I mean,
I
you,
haven't taken any alcohol. It
All
was my
right.
son's birthday and
I don't want to hear anything. Look, these are 19 and 20 cases, okay? And you failed to appear on one in 2020. So right now, I think that the public's at risk with you out, not keeping clean and drinking. Okay, that's what I think. Right. So I mean, and that I just want you to understand that you got to stay away from alcohol. You can't have scrams going positive, all this, because these are older cases and there's some discovery issues. But I'm a little worried that the allegation is you've been drinking and on 2 drunk drivings. Okay, these are both set for drunk driving. And then the final pretrial is also, I believe that's a drunk driving. So, so just keep it clean, all right? All right. All right, so for the contempt hearings on 1904767 and 20-03514, those will both be adjourned for discovery issues to August 26th at 8:30. So that's all for the record on those. And then we have 20. And we still have a final pretrial on 23514. So that's the underlying, and how did you want to proceed on that? Mrs. L, does that it seems like we have the same discovery issues.
Correct, Your Honor. We would ask for that one to be adjourned as well.
That previous file has already been adjourned, but we'll adjourn it for the final pretrial and set the final pretrial for that date on August 26th at 8:30. So realistically, Ms. Jones, there's 2 files, right? There's a contempt on one, and then there's the pending, and this is a 20-3514. It's a pretty old case, 5 years old. So we'll adjourn that to August 26th at 8:30. Anything else for the record in that file for that final pretrial on docket 20-03514?
Not for people.
Ms. Wicks.
No, thank you.
All right, Ms. Jones, good luck to you. We'll see you on August 26th.
And I believe we're ready on Portia Gregory.
Yes, Your Honor.
Largest joint military drills. This comes at a time when tensions between the United States
That's it for final pretrial.
and unseen since the Cold War.
Mr. Moore, you should mute because the courtroom can hear you. So you should mute yourself. All right, we're on the record in docket 24-01831. That is people of the state of Michigan versus Portia Gregory. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender and James Harris here on behalf of Ms. Gregory, who is standing to my right, Your Honor.
And ma'am, you are Portia Gregory, is that correct?
Yes, sir.
All right, thank you. This is the time set for final pretrial in the matter. Mrs. L, how we proceed?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date, and we have been in contact with them. They did indicate that they did not want to come today. We do not believe that they would be here if we put this off any further. At this time, we do expect a motion from the defense.
So they were subpoenaed. It's been unsuccessful contact with them, and you're unable to proceed.
Correct, Your Honor.
Mr. Harris.
Yes, Your Honor, given the prosecution's inability to proceed, we would request that this case be dismissed at this time. I would request that a copy of the dismissal once signed be provided to my client.
All right, I am in possession of the dismissal or nollie process on 2401-831. Based on the defendant's motion, this case is dismissed without prejudice. What that means, Ms. Gregory, is the people could reissue if they choose to. Realistically, for our case, for our purposes today, the case is dismissed. There's a no contact order. So you should carry, I'm going to sign this dismissal and provide you with a copy. You should carry it with you. I'd say, because it takes about 2 or 3 hours to purge everything from the system, from the computer system. And there is still a no contact order, so carry it with you just in case.
Thank you.
All right, I've signed the order of acquittal. Anything else on 2401-831, Mrs. L?
Not for the people.
Mr. Harris.
Not for the defense, Your Honor.
All right, Ms. Gregory, you're all set. You can get a copy from my court officer. Thank you for your appearance.
Thank you.
'Under the moniker of Lauren, you're in a blue shirt. I can't see your face because it's covered by monitor. Can you please tell us what case you're here on?
What are you here for?
I'm here for the destruction of property.
What's the name of the case?
Bernard Greer.
Bernard Greer. So you're a victim in that case?
No,
No,
I'm
it's
not
over
the
9 a.m.,
victim.
Your Honor.
Oh, so you are Bernard Greer.
Yeah.
All right. All right. That's 9. You're here for the 9 o'clock standby. And then Mr. Moore, what case are you here on? Charles Moore.
I am the guardian for Bernard Greer.
All right. All right. So you're here on that case. All right. Thank you, sir. And then Rogers. Somebody from Ingham. (25) is 01900. That is people of the state of Michigan versus Emilio Lira. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Emilio Lira, who's standing to my right, Your Honor.
And sir, you are Emilio Lira, is that correct?
Yes, sir.
All right, thank you. This is the time set for a final pretrial in the matter. Mrs. L, how we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear and we are unable to proceed forward. We have not had any successful contact with these witnesses either. At this time, we do expect a motion from the defense.
All right, Mr. Harris.
Yes, Your Honor, given that the complaining witnesses have failed to appear, we would be requesting that the case be dismissed at this time. I would request that a copy of the dismissal be provided to my client.
Thank you. All right, based on the prosecutor's representations that the complaining victims or the witnesses were subpoenaed and there has been no positive contact, people are unable to proceed on docket 25-01900, and based on the motion from the defense, we will dismiss without prejudice. Mr. Lira, that means that this case could be reissued if they choose to, but for our purposes today, the case is dismissed. I will sign the dismissal accordingly. There is a no contact order, so you should probably keep a copy of this with you just to show, because it takes about, I'd say, 4 or 5 hours to purge the computer system, and you don't want to be picked up on something that we know is dismissed, but the computers say it's not dismissed. So belt and suspenders approach. You can get a copy of this order of acquittal from or dismissal from my court officer. Anything else for the record in 25-01900, Mrs. L?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right, Mr. Lira, you're all set. Thank you for your appearance. And my court officer will give you a copy. All right, so we're on the record in docket 25-01855. That is people of the state of Michigan versus, I'm sorry, 25-00978. That's people of the state of Michigan versus Lance Gailey. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Gailey, who I believe is joining via Polycom from the jail, Your Honor.
And sir, you are Lance Gailey, is that correct?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. My understanding is there is an outstanding forensic. We're awaiting a forensic on another felony file. Ms. Zell, how would you like to proceed?
Your Honor, we would ask at this time for this file to be set for that same date for competency review. We believe that if that issue exists in the felony file, it exists here as well.
And is that a fair statement, Mr. Harris?
Yes, Your Honor. My understanding is he was referred to competency on a felony file where he's represented by Assistant Public Defender Aaron Schroeder. I was intending to make that same request and to have this case referred to competency, or at least held until we have a competency determination, as I do not know if we can reasonably proceed with this case while his competency is potentially at issue.
I would agree. So let's set it for the control date, same control date as the other file, the felony file, in which is in review. And we'll set it so we don't lose track of this file or the next file, because I think the evaluation is set for September 6th. So September 6th is the evaluation.
And the review date is October at 8:30.
Well, and then the review date will be, or the control date will be October.
October 10th. I'm sorry, October 3rd,
What time?
8:30.
Okay, so we'll set this with the forensic on the felony file for October 3rd at 8:30. Anything else for the record in 25-00-978, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, Mr. Gailey, we'll see you on that October 3rd date. Thank you for your appearance. You're all set.
All done.
All right, Ms. Rogers, we'll call your case. So you can unmute, ma'am. So we're on the record in docket 25-01118. That is People of the State of Michigan versus Caitlin Rogers. So the parties please introduce themselves to the record. Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Kate Rogers, who appears via Zoom, Your Honor. She does apologize for appearing via Zoom. She realized it was originally scheduled for in person. However, she indicated that she recently had a death in the family.
All right, ma'am, you are Caitlin Rogers, is that correct?
Correct, Your Honor.
Right, thank you. This is time set for a final pretrial. Mrs. L, how we proceed?
Your Honor, at this time, a plea offer has been extended to defense. It's my understanding that that plea offer is going to be accepted today. The offer is for Ms. Rogers to plead to an attempt retail fraud third, which would be under MCL 750.356D4. I believe that's followed with a capital A for the attempt. I believe it cuts it down to a 45-day misdemeanor and or a $250 fine. Please correction if I'm wrong about that. And we would be agreeing to a no upfront jail for sentencing.
Yeah, that is a correct approximation of the offer, Your Honor. Additionally, I believe we are not expecting any restitution on this, and my understanding is we don't have formal documentation of the specific amount.
That is my understanding as well, Your Honor.
And if I did not state that, Your Honor, I apologize. My client will be accepting that offer at this time.
All right, so we'll do an added count 2. Of attempt retail fraud in the 3rd degree. That is under 750.356D4A. It's a 45-day misdemeanor and or $250. There is a Killebrew agreement of no upfront jail. And with successful plea and sentence on count 2, on the added count 2, count 1 is to be dismissed. Did I miss anything else as part of that plea offer, Mrs. L?
No, that all sounded correct to me.
All right. Is there any, do you have any objection? I don't know what restitution, do you have an objection to an immediate sentencing?
I do not, Your Honor.
All right. And is that a fair statement, Mr. Harris?
Yes, it is a fair statement, Your Honor.
All right. Mr. Harris, may I inquire of your client, Ms. Rogers, for misdemeanor advice and rights?
Yes, Your Honor.
All right, Ms. Rogers, you have the following. First of all, that is your understanding of the offer to plead to the attempt retail fraud. It's a 45-day misdemeanor and or $250. There's an agreement between the attorneys that you not serve any upfront jail. If I was going to do something separate from that agreement, you understand you'd have the right to withdraw your plea. Do you understand that, ma'am?
Yes, Your Honor.
All right. All right, so you have the following rights in this trial, in this jury trial misdemeanor file, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty. You have the prosecutor prove beyond reasonable doubt that you are guilty. To have witnesses against you appear at trial. To question any witnesses that are brought against you. You are represented today by Attorney James Harris. He would be present, or his office would be present, to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes, Your Honor.
All right. You have the right to have the court-ordered witnesses in your defense remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading to the attempt to retail fraud in the third degree misdemeanor instead. Is it still your wish today to plead guilty to the misdemeanor instead?
Yes,
All right. I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
yes, Your Honor.
All right. I'm gonna bring your attention, ma'am, back to March 2nd, 2025 at 5640 South Martin Luther King Boulevard in the city of Lansing. Were you present in the city of Lansing on Martin Luther King Boulevard on March 2nd, 2025?
Yes,
Okay. And at that time, was you there at that time is a Dollar General. Was the Dollar General open to the public?
yes,
And at that time, did you attempt to steal property from Dollar General that was less than $200?
yes,
All right. And you didn't do so by accident. You knew at the time you were taking property without stealing, without the intent to pay for it. Is that correct?
correct.
All right. Anything towards the factual basis, Mrs.
No, Your Honor, thank you.
Mr. Harris?
Nothing to the defense, Your Honor. Thank you.
I find the factual basis to be knowing, voluntarily, and accurately made, and without objection from the people, we can go to immediate sentencing. Allocution, Mr. Harris.
Yes, Your Honor. Ms. Rogers is apologetic for this incident and for the actions she took on that day. She is trying to take responsibility for what she did. At this point, I would request the court simply sentence her to a fines and costs sentence. If the court would consider minimal fines and costs, as Ms. Rogers did indicate to me that she has recently had a death in her family, and as a result, she and her family are going through a bit of a period of financial hardship, so I would request that the court consider minimal fines and costs for this case, Your Honor. Thank
She
you.
would need some time to make that payment.
Yes, she indicated she could, and that regarding the whatever payment she could make that within 90 days, Your Honor.
All right. Anything towards the allocution on this case, Mrs. Allen?
Just briefly, Your Honor, it does look like this is Ms. Rogers' first retail fraud. Her first retail fraud. We would ask that you take that into consideration as well. Thank you.
And then you don't have any restitution on the file from Dollar General.
Your Honor, I do have a description of 3 items that were taken with the price of those. I'm trying to pull it up now. My computer is a little slow. It looks like we have in the police report that a Toastmaster coffee maker at $26.50, a laundry basket at $20.75, and a bath towel at $10.
Were those recovered and given back to Dollar General? I know probation is going to request, and if they got the items back, then we don't have to worry. But if we don't have the items, then restitution's in order.
It does not look like the items were recovered. No, the items were not recovered, Your Honor. And these were the only items that were able to be identified by the store employees.
Okay, so do we want to refer to probation for a pink sheet, or?
We can, Your Honor, if that's preferred.
That's my question, because I know restitution is gonna start, it's gonna become a thing, because Dollar General's not contacted. We're looking at an immediate sentencing, and it becomes an issue.
Correct, Your Honor. Yeah, at that point, I guess we would be asking for that to happen.
All right, let's do that. Miss Rogers, we're gonna refer you to probation, really on the subject of restitution. Probation's on the 5th floor of City Hall of Lansing. And you have 2 days to get to probation, which will be by Thursday, make it Thursday, August 7th. You should get to probation. They'll see you. What they're gonna do is they're gonna put together a report. So we'll hear from Dollar General concerning restitution in this matter. And then we'll set for, so that's on the 5th floor of City Hall of Lansing. And then we'll set for sentencing on. I'm all for immediate sentencing. I just think that, I think we're gonna get caught up in this restitution thing. All of us, Mr. Harris is, Mrs. L, you are, and I am too. So let's get it clarified up front. At least Mr. Harris knows at sentencing what the amount is that his client's admitting to concerning the restitution number. All right, Ms. Rogers, so we'll see on October 14th at 1:30. Is the Hughes Street address still a good address for you? Is that Hughes Road address still a good address for you, ma'am? I think that was a yes.
It looks like.
Yes, it is.
All right. So we'll see on October 14th at 1:30 for sentencing. Anything else on
Yes.
25-01-118, Mrs. L?
Not for people.
Mr. Harris?
Nothing to defense, Your Honor.
All right, thank you. We're all set. You're all set, Ms. Rogers. Thank you for your appearance.
Your Honor, if we could jump down to the 9:30 docket, Mr. Richard Scott needs to get out of here, so if we could call his case. I understand, we'll be really quick.
Ma'am, you guys, she'll call the cases and we'll go forward, all right? All right, so we'll go on Richard Scott. All right, so we're on the record in docket 25-02200. That is people of the state of Michigan versus Richard Scott. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender on behalf of Mr. Scott, who is present standing to my right.
And sir, you are Richard Scott, is that correct? All right, thank you. This time set for a pretrial in the matter. Mrs. L, how we proceed?
Your Honor, we're going to be asking for this to be set for a final pretrial.
And is that a fair statement, Ms. Wicks?
It is.
Right, we'll set for final pretrial on
August 26th at 8:30.
August 26th at 8:30. All right, so we've set this for final pretrial on August 26th at 8:30. Anything else for the record in 25-02200, Mrs. L?
Not for the people. Thank
Ms.
you.
Wicks.
No, thank you.
All right, Mr. Scott, we'll see you on August 26th at 8:30. Thank you.
And then, Your Honor, you could go ahead and move to the Ann Savage case when you're
All right.
ready.
So on the record in 25-01898, that is people of the state of Michigan versus Ann Savage. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Ms. Wicks,
Assistant
Mr.
Public
Harris.
Defender James Harris here on behalf of Ms. Savage, Your Honor.
and ma'am, you are Ann Morgan Savage, is that correct? All right, thank you. This is a time set for a pretrial in the matter. Ms. Zell, how we proceed?
Your Honor, it's my understanding that this may have been a little bit of a scheduling error. We think this may have been, or should have been a final pretrial. However, since it was set for a pretrial, the people did not send out subpoenas for today's date.
Set for final pretrial on today's date.
Correct. So we do want to be transparent here. We did not subpoena the witnesses for today's date. They are not here. They are not present. We would be asking for this to be set for another final pretrial, in a shorter time period, preferably 2 weeks, so we can get that subpoena out. But we also, just so we don't have this case sitting on our docket for too long either.
We have twofold. We can set it for final pretrial, or we can just set it for jury trial and see who shows up for jury trial.
I will defer to defense on that one and let them know.
Mr. Harris.
Thanks, Your Honor. I guess to start, if the court would consider dismissal at this time, I would request that. I will note that while it was set on the court's docket as a pretrial, as far as the notes indicate, it was intended to be a final pretrial. It was stated to be a final pretrial on the docket last time we were in court. If the court is not willing to dismiss at this time and is willing to reset, I would request that the court, that this case be reset for another final pretrial, Your Honor.
So so I'm not going to dismiss because the witnesses weren't subpoenaed, and so that'll be. So if there's an adjournment, it'll be on the prosecutor. And then the request is to have this reset for final pretrial as opposed to going right to jury trial. And I'll honor that request. So we'll adjourn, and the adjournment is on the prosecutor for purposes for this adjournment, or request for adjournment, and we'll set for final pretrial.
We'll set for August 26th. I did schedule it, correct?
Okay, August 26th at 8:30. So Ms. Savage, putting it out 2 weeks for the additional final pretrial. If the witnesses show, we'll deal with it then. If not, then Mr. Harris, he'll make his motion. Okay, ma'am? All right. Anything else for the record in docket 25-01898, Ms. Azal?
Not for the people.
Mr. Harris?
Not from defense, Your Honor.
All right, I'll see you on August 26th at 8:30. Thank you for your appearance, Ms. Savage. Ms. Smith?
Yeah, Ms. Desiree Smith, Your Honor.
All right, so we're on the record in docket 25-01908. That is People of the State of Michigan versus Desiree Smith. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Smith, who's standing to my right, Your Honor.
And ma'am, you are Desiree Smith, is that correct? Thank you. This is the time set for final pretrial on the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. We did send out subpoenas for today's date, and we have not had any successful contact with them. At this time, the people are unable to proceed. We do expect a motion from the defense.
Yes.
Mr. Harris.
Yes, Your Honor. Given that the complaining witnesses are not present today, we would ask that this case be dismissed. I would ask that a copy of any dismissal be provided to my client.
Thank you. All right, I am in possession of the order of acquittal or dismissal on case 25-01908. Based on the prosecutor's representations of their inability to proceed, complaining victim was subpoenaed and there's not been any successful contact. I'm going to grant the motion to dismiss without prejudice. So, Ms. Smith, this means that the case is dismissed without prejudice, means that people could reissue if they choose to, but the dismissal without prejudice is kind of a default. So default here is that the case is dismissed. There is a no contact order. So you should get a copy of this, okay, to keep with you, because it takes about 3 or 4 hours to purge it from the computer system. So you can show this so you don't get picked up on the no contact order. Is that a fair statement, Mr. Harris?
Yes, Your Honor.
But I'll sign the nollie pros or dismissal without prejudice. And then you're gonna get a copy for my court officer. Anything else for the record in 25-01908, Mrs. L.
Not for the people.
Mr. Harris.
Not for the defense, Your Honor.
All right, Ms. Smith, you're all set. Thank you for your appearance today.
All right, thank you.
You're welcome. Did you, I think
We
Mr.
might be ready to go on, Mr. Wood.
Mr. Woody? He's not, I think this is Mr. Woody.
It's in the prelim room. I don't know.
Yeah.
Yes,
I think that's,
I did see him there previously, so I can confirm he at least was in that room previously.
this was set for final.
I'm here. I'm right here.
All right.
I can't,
All
you
right, so
guys
we're
are
on the
frozen.
record. We're on the record in 25-01443. That is people of the state of Michigan versus Stephen Woody. With the appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izzo, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Woody, who is joining the Polycom from MDOC, Your Honor.
And sir, you are Stephen Clay Woody, is that correct?
Yes, Your Honor, that's correct.
All right, thank you. This is a time set for a final pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date. We have not had successful contact with them about this matter. We do expect a motion from the defense at this time.
Okay,
Yes, Your Honor. Given that the complaining witnesses have failed to appear at this time, we would be requesting this case be dismissed. And I would request that if at all possible, for the court to email a copy, or well, not email, mail a copy of the dismissal over to MDOC for Mr. Woody. My understanding is part of the reason he's currently there is a parole hold that this case may at least be part of. So some notice to them that this case has been dismissed, I believe, would be helpful in resolving his parole matters with MDOC.
and what is this? We have them East Michigan Avenue as the address, but he's obviously not at that address. What institution are you at, sir?
I'm at Jackson Correctional Facility, Cooper Street.
Okay,
It's RGNC, the intake center.
all right. We know exactly where you are. RGC. All right. Based on the prosecutor's representations that they cannot go forward and people are unable to proceed, it appears that there's been unsuccessful contact with the complaining victim. They were subpoenaed. Is that correct, Mrs. L?
That is correct, Your Honor.
And based on counsel's motion, we will dismiss without prejudice. And then we will send a copy of the dismissal. I'll sign to the Jackson Correctional Facility, the RCG address. And then, so you should have a copy of the dismissal. They will also have a copy of the dismissal. Anything else for the record in 25-01443, Mrs. L?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right, Mr. Woody, you're all set. Thank you for your appearance today.
All right, I appreciate it.
Makes sense then.
Right, where are we heading next, Mrs. L?
I believe we're ready on Lee Brandis.
Yes, Your Honor. Mr. Brandis is here in person.
All right. All right, so we're on the record in docket 25-01751. That is people of the state of Michigan versus Lee Brandis. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izzo, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Lee Brandis, who is standing to my right, Your Honor.
And sir, you are Lee Brandis, is that correct?
That's correct.
Thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, a plea offer has been extended to the defendant through defense counsel. That offer would be to plead to an added count 2 of a false report of a misdemeanor under MCL 750.411A1A, which is a 93-day misdemeanor and/or $500 fine. Upon successful plea and sentence to that, we would be dismissing count 1, the unauthorized use of emergency services. Additionally, Your Honor, we would be agreeing to a Killebrew of no upfront jail in this case.
Yes, Your Honor, that is the offer. That is a correct statement of the offer that was conveyed to me. I did speak about that offer and our options in this case with Mr. Brandis yesterday. He did indicate to me that he would be willing to accept that offer at this time, Your
All
Honor.
right. So let me make sure I've got the plea offer correct. It is a plea to count 2. Plea to count 2. And that is a false report misdemeanor.
Correct.
Violation.
It's pronounced.
I pronounce it the way I do.
With a,
The way I would say it. I don't give a crap.
It doesn't sound.
Mr. Greer. All right, with a plea to count 2 of the false report misdemeanor under 750 point, this is where 411A1A,
Yes.
93-day misdemeanor and or $500. With a successful plea to count 2, count 1 is to be dismissed. There's a Killebrew agreement of no upfront jail. Would that be a fair statement, Mrs. L?
That is correct, Your Honor.
Mr. Harris.
Yeah, that is a fair statement, Your Honor.
All right. Mr. Harris, may I inquire of Mr. Brandis of his advice of misdemeanor rights?
Yes, Your Honor.
All right. Mr. Brandis, you understand you have the following jury trial rights. I'm going to walk you through those, okay? Yeah, on this file. You have the right to be tried by a jury, to be presumed innocent till proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney James Harris. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Is that your understanding, sir?
Yes.
You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'll also be giving you the right to appeal from a trial. Since you won't be having a trial, you'll be pleading guilty to the misdemeanor, false report misdemeanor instead. Is it still your wish today to plead guilty to the false report misdemeanor count 2? Is it still your wish today?
Yes.
Okay. Sure. All right, I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I'm gonna bring your attention back to June 12th, 2025 at 2236 North Grand River in the city of Lansing. Were you at 2236 North Grand River or calling that agency in the city of Lansing on June 12th, 2025?
Yes, it was.
Okay. Mr. Harris, did you want to use the factual basis for count 1, or do you want to go for it on the count 2 factual basis? Doesn't matter.
I think it should be simple enough to use the factual basis for count 1.
Okay. Did you use or attempt to use an emergency 911 service for the purpose other than calling an emergency?
Yes, accidentally. I did.
But accidentally is not going to cut it. You've got to do it intentionally.
Okay. Yes.
Okay. Yeah. All right. So this was not done at accident. It wasn't done by accident. It was done purposely, calling 911.
Yes, it was. At the time.
Okay. Anything towards a factual basis, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
Okay. I find the factual basis to be knowing, voluntarily, and accurately made. With the Killebrew of no jail, did you want this referred to probation, or?
We would ask this to be referred
All
to
right.
probation.
Right, the Kilbrew no upfront jail means that the sides have agreed no upfront jail. If I was to do something different from that, you'd have the opportunity to withdraw your plea. Do you understand that? All right. All right, we're gonna refer to probation. And they're gonna do a sentencing report for me, and then we'll see what options are available to us. So we'll get a sentencing date of
October 14th at 1:30.
October 14th at 1:30. So probation is on the 5th floor of this building, all the way to your right. They may meet with you, they may see you then, and then we'll see what options are available to us on October 14th, right, sir? Anything else for the record in 2501-751, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, Mr. Brandish, we'll see you on the sentencing date. Thank you for your appearance.
Thank you, Your Honor.
I think we're
Did
ready
you want to go on Greer?
Yeah.
All right, so Mr. Greer, you can unmute. We'll call your case. Thank you.
Yes, Your Honor.
All right, so we're on the record in docket 2501-855. That is People of the State of Michigan versus Bernard Greer. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Lizelle, Assistant Prosecutor for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, filling in for Attorney of Record George Mead on behalf of Mr. Greer, who is present via Zoom.
And sir, you are Bernard Greer, is that correct?
Yes, that's correct.
Okay, and you can hear me all right, Mr. Greer?
Yes, I can.
Thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this case to be set for a final pretrial.
And is that a fair statement, Ms. Wicks?
It is.
All right, we'll set for final pretrial. And that'll be live in person. So it'll be live in person on the 6th floor of City Hall of Lansing. We'll set for final pretrial on
August 6th at 8:30.
August 26th at 8:30.
So it's
So
in
Mr.
person.
Greer, yeah, it'll be in person on the 6th floor of City Hall of Lansing. All right, Mr. Greer?
Okay.
All right, and Mr. Ned should be back, I would think at that. You'll have somebody from the Public Defender's Office, but most likely it'll be Mr. Ned who's assigned to this courtroom. All right, anything else for the record in 2501-855, Mrs. L?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Mr. Greer, we'll see you on August 26th at 8:30. Thank you for your appearance today. You're all set.
Okay.
Ms. Stewart, are you represented today?
She declined.
Do you know how to unmute?
Wendy said she-
Yeah, we still have you as muted, ma'am.
Okay, can you
There
hear
you
me now?
go. I can hear you now. Ma'am, do you plan to seek counsel in this, or would you like to meet with the assistant prosecutor?
Uh,
Because we don't have you as represented, and we have, you were defined, you were denied by the,
She declined.
oh, okay. So Ms. Stewart, we have that you never applied or declined representation by the Public Defender's Office. Did you plan to represent yourself or to seek your own counsel?
represent myself
Did you want to meet with the assistant prosecuting attorney?
if I can.
All right. Mrs. L, did you just want to put this on the record?
Yeah, I think we can do that.
All right. All right, so we're on the record in docket 24-02203. That is People of the State of Michigan versus Shauna Stewart. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Lizelle, Assistant Prosecutor for the people.
And ma'am, you are Shauna Stewart, is that correct?
Yes.
All right, thank you. And you are not represented by counsel at this time, is that correct?
Correct.
All right, this is time set for a pretrial in the matter. Mrs. L, how are we proceeding? We're all on the record, so you can indicate the offer from the people.
Thank you, Your Honor. This is a dog license case that seems to be from August of 2024. So at this point, we would just be asking for proof of a valid dog license, or if the dog is no longer in possession of Ms. Stewart, proof of that. At the next pretrial or final pretrial, if we have that, we would be able to have this case dismissed for compliance.
All right, Ms. Stewart, did you hear that?
I did.
All right, so you can either proof of the dog getting licensed or proof of non-ownership of the dog, like you've handed the dog over, that would be compliance. And if you provide proof of that to the prosecutor, they would be willing to dismiss the case.
Oh, okay. That my dog he's no longer living. He was ran over by a car.
Oh, so do you have any certification of that you could provide to the prosecutor?
I don't have any. I wasn't there when he was hitting. It was a hit and run, and I wasn't there.
All right.
Can I ask, what day did this occur? Do you recall what day?
Oh, geez.
No. An approximation would be okay.
It's been a while. I'm in Flint. I was only in Lansing visiting at that time, but oh goodness, it's been probably almost a year.
Okay. Your Honor, at this time, I think the people would be okay with going in with moving for a dismissal at this time.
That would put it around a year from now would be, because this is written on July 20th. Yeah, we're in the same ballpark. All right, so for compliance measures and based on what was indicated on the record, Ms. Stewart, I'm going to dismiss without prejudice. Your indication on the record is that you're no longer in control of the dog because the dog is now deceased. Is that correct?
Correct.
All right. All right. So for compliance purposes and for the dismissal for without prejudice because the dog is now deceased. Anything else for the record in 24-02203, Mrs. L?
Not for the people.
All right, Ms. Stewart, you're all set. Thank you for your appearance today. This has been dismissed for compliance purposes.
Thank you.
You're welcome.
Your Honor, that is Miss Mays in the back of the courtroom. She had a show cause
All right.
hearing.
Previously. You have any show causes today?
Not today.
Ms. Mays, when was your show cause?
I'm sorry.
When was your show cause hearing?
It's set to be here at 9:15 today.
I don't think that's with us.
What's your first name?
Ashley.
Ashley, let's find out. Let's find out where you're supposed to be.
Okay. Can you spell your last name? Mays, M-A-Y-E-S. It said Flores on my paper, so.
I think it was yesterday. Our show causes were yesterday.
She has a pretrial with us on August 18th.
That's for.
Or actually not with us, it's with Judge Buchanan.
So you have August 18th, Judge Buchanan, and then we don't have you on the docket for August 5th.
I left the paper at home. I'm looking back.
Let's see.
I
Maybe
believe
we
it's
can-
on the 24-422 SM file.
24. Say it again. Ms. Mitch.
422.
24-422.
This is a collections matter. She needs to go to collections department for a show cause.
All right, so it's with the City of Lansing Collections. So you should probably go see, I bet Marquita,
I believe.
but you probably should go start at the counter.
I will walk her
Okay.
over
They
to
said-
either
they
the counter or.
The 5th at 9:15.
It is, but it's for the counter. It's not for here.
Oh, they told me to come here.
And then your
I went to
other,
the counter.
yeah, and And then your pre-trial on your other cases in front of
Yes.
Judge Buchanan.
Yeah, I printed her a note.
Okay.
Yeah, I
perfect.
have that one.
You should be
Okay,
all set.
Thank
then.
you.
Thank
Thanks,
you.
Wendy.
You're welcome.
Yeah.
I sent you, Mr. Harris, and everybody I could think of a email about McGriff.
Yeah, I'm reading it right now.
Okay, yeah, I don't really know what you guys want me to do with that mess.
Hmm. I'm not sure even.
Yep.
But for some reason, I can't hear them. I think maybe because I can fix that. It's problems. And then it'll be what up in court while I was in and like,
Hello?
Hello. I'm not sure. Are you a participant or
I am, I here for Judge Flores's room.
I see? Yeah, I am as well. I've been waiting. So you're waiting to see Judge Flores?
Yes.
Yeah, yeah, so am I. Just give it a
Oh,
moment. I think they're all waiting for something. I'm not sure.
gotcha. Thank you.
Yeah, you're welcome.
All right, so we're on the record in docket 25-01786. That is people of the state of Michigan versus Khalil Withers Fleming. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, filling in for Attorney of Record, Mr. Anid, on behalf of Mr. Withers Fleming, who is present standing to my right.
And sir, you are Khalil Withers Fleming, is that correct?
Yes, sir.
Thank you. This is the time set for pretrial in the matter. Mrs. L, how we proceed?
Your Honor, it's my understanding we're going to be asking for a final pretrial.
Is that a fair statement, Ms. Wicks?
It is.
Okay, the final pretrial will be set on
August 26th at 8:30.
August 26th at 8:30. All right, so that'll be live on the 6th floor of City Hall of Lansing. We've set it for August 26th at 8:30. Anything else for the record in 25-01786? Mrs. L.
Not for the people.
Ms. Wicks.
No, thank you.
All right, Mr. Withers Fleming, we'll see you August 26th at 8:30. That'll be live, right, like we are now. You should be all set.
Thank you.
She'll hand you your notice whenever you go.
Have a good day.
You too.
Thank you.
And then I believe we're ready on Marshall Hawk, who I believe is appearing via Zoom.
Yes.
All right, so Mr. Hawk, we'll call your case. So we're on the record in 25-454-29281. That is people of the state of Michigan versus Marshall Hawk. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izell, Assistant Prosecutor for the people.
Ms.
Taylor
Wicks.
Wicks, Assistant Public Defender, on behalf of Mr. Hawk, who is present via Zoom.
And sir, you are Marshall Hawk?
Correct.
Thank you. And you can hear me all right, Mr. Hawk?
Yep.
This is the time set for a pretrial in the matter. Mrs. L, how we proceed?
Your Honor, at this time, defense has provided proof of proper registration for the vehicle that this ticket is related to. At this time, we would ask for a dismissal for compliance purposes.
And that you have no objection to that, Ms. Wicks?
Correct.
So for compliance purposes, and this is on a ticket, we will dismiss without prejudice based on the prosecutor's representations. So Mr. Hawk, this is dismissed without prejudice for compliance purposes. Anything else for the record in 25-454-29281, Mrs. L?
Not the people.
Ms. Wicks?
No, thank you.
All right, Mr. Hawks, you're all set. Thank you for your appearance today.
Thank you.
What's next?
Miguel Perez, I believe.
That's two files. Did you want both those files called together? Should we treat them separately?
We can call them together.
All right, so we're on the record in docket. Mr. Perez, we're going to call your case. You can unmute. We're on the record in docket 25-01969 and 25-02050. Appearances for the record. Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Wicks.
Taylor Wicks, Assistant Public Defender, filling in for Attorney of Record Georgia Need on behalf of Mr. Perez, who is present via Zoom.
And sir, you are Miguel Perez, is that correct?
Yes, sir.
Okay, and you can hear me all right, Mr. Perez?
Yes, sir.
Thank you. This is time set for a pretrial in the matter. Mrs. L, how we proceed?
Your Honor, it's my understanding we're going to be asking for both files to be set for final pretrial.
Okay, and is that a fair statement, Ms. Wicks?
That is my understanding for Mr. Enid's notes.
Okay. All right, on file 25-01969, we'll set for final pretrial.
August 26th at 8:30.
And then on file 25-02050, same date and time.
Yes.
So it'll be August 26th,
At
8:30. 8:30. All right, we've set both files, and that's 25-01969 and 25-02050 for August 26th at 8:30. Anything else for the record in docket 25-02050 for 25-01969, Mrs. L?
Not for the people.
Ms. Wicks?
No, thank you.
All right, Mr. President, you're all set. We'll see you on that August 26th date.
So do I still have court on the 7th?
Yeah,
Yeah. He is about
Yes.
me.
yeah, you've got a different file on the 7th. And then you should show up live in person on the 6th floor City Hall on August 26th at 8:30 on these two files.
Okay, so 7th I can show up Zoom?
I don't, that's a felony. It's probably, is that a PCC or pre?
That's a prelim.
Yeah, you'll have to be live in person on that, on
Okay,
that
thank-
date.
All right, thank you, sir.
All right, so you're all set. Thank you, Mr. Perez. All right, so we're on the record. Mr. Portion, we'll call that case. We'll call your three cases of 25-01828, 25-01829, and 25-01830. That is people of the state of Michigan versus Leonid Portion. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
And sir, you are Leonid Portion?
Leonid Poroshin, yes.
Okay, thank you. And this is the time set for, and Mr. Portion, you are not represented by counsel on these three files, is that correct?
That's correct.
All right. This is the time set for pretrial in the matter. Mrs. L, you may put the offer on the record.
Thank you, Your Honor. At this time, we do believe, I believe that this is 3 dog license cases. I'm unsure if it's the same dog or 3 separate dogs.
I think it's
However,
3 separate.
perfect. If we can get proof of valid dog licenses for all 3 dogs, or proof that these dogs are no longer under the ownership of Mr. Portion, then we would be willing to dismiss the case.
All right, so Mr. Portion, you understand the offer from the people of the state of Michigan is proof of, either proof of compliance or proof that you're not the owner anymore.
Yes, I do, and I have the proof of compliance. They're all licensed now.
All right, so why don't we set this out and then you can tell us if we need it or not once you receive that proof.
Sounds wonderful.
All
Can
right.
my email potentially be sent to Mr. Portion?
Maybe, let's see. Can you send Mr. Portion the email? Is that a yes?
Yes.
Yes, it can.
Thank you.
So, Mr. Portion, we're gonna send you the email and you should send the proof of compliance to that email for the assistant prosecutor, all right?
Would it be the Ingham County dog license information?
Yes. Well, that's the information she would need,
Yes.
but that
Yeah.
should be provided to the email address that's gonna be provided to you.
Can you
Okay.
make him, ask him to confirm that he got my message?
Do you have the
Okay.
message from us
I
concerning the
just
email
re-
address?
I just received the message, yes.
Yes. All right. All right,
Uh,
so let's set this for final pretrial just as a date, a control date.
Final pretrial or
Let's adjourn to pretrial.
Okay.
That's a good
I-
idea.
I can send back the proof within the next few minutes.
All right, what we'll do is, once you send her the proof, Mrs. Zell will let us know if we need the hearing or not. We're just gonna set it as control date. All right, sir?
Okay, so will I need to appear for another pretrial?
You may not. You may not if you hear from the assistant prosecutor that you don't have to, once compliance is met. So you should send her any information that you have, but we're gonna set it just in case for an adjourned pretrial. You probably, if she receives that, you probably won't have to appear, but you should wait to hear from her.
Okay,
All right, so we'll adjourn the pretrial to
August 26th at 9:30.
30. August. All right, so Mr. Portion, make sure that you send the information to Assistant Prosecutor Mrs. Zell, and then we'll set this for August 26th, and then Mrs. Zell will let us know if we need that hearing and whether you need to proceed, whether you need to appear or not.
do you need the photos of the paper or photos of the tags? Or both?
Photos of just the license is enough. Our understanding is you can't get the license without the tags for the vaccinations. So the license is enough, and then I'll respond to that email with more information.
Okay,
All right. Anything else for the record in 25-01-830-29 or 28, Mrs. Zell?
Not for the people.
All right, Mr. Portion, you should be all set. Thank you for your appearance today.
thank you. Checking out.
Okay. All right, so we're on the record in docket 25-01937. That is People of the State of Michigan versus Muhammad Shakur. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Shakur. He is appearing via Zoom, Your Honor.
All right, correct my pronunciation, sir. You are Muhammad Shakur?
Yep, my name is Muhammad Shakur, Your Honor.
Muhammad Shakur. Thank you.
Muhammad
This is the time
Shakur.
set for
Yep.
a pretrial in the matter. Mrs. L. And Mr. Shakur, you can hear me all right?
Yes, sir, I can hear you.
All right. This is time set for a pretrial. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that this case is, or we're going to ask for this case to be set for a final pretrial. An offer was extended to defense at this time, and it's being taken into consideration before that final pretrial.
And is that a fair statement, Mr. Harris?
Yes, Your Honor, I have gone over the offer with Mr. Shakur. He has indicated he would like some time to consider that offer and also speak with the attorneys who represent him on other cases, including a felony file that I believe is before Your Honor this week.
Okay.
So we would be asking for a final pretrial to give him some time to consider the offer and his options.
So you're using that August 26th. Okay. What time?
8:30.
So we'll set for final pretrial for August 26th at 8:30. And you, the last updated address is at Greencrest Avenue address. Is that still a good address for you, Mr. Shakur?
Yes, sir, that's correct.
Perfect. All right, we'll see you on August 26th at 8:30 on this retail fraud file. Anything else for the record in 25-01-937, Ms. Gazelle?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, Mr. Shakur, you're all set. Thank you for your appearance today.
Thank you, Your Honor. You have a great day.
You too. All right, so Chelsea King, you can unmute. All right, we're going to call your case next. So we're on the record in docket 25-01125. That is People of the State of Michigan versus Chelsea King. Appearances for the record, Mrs. Ellen.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Chelsea King, who appears via Zoom, Your Honor.
And you are Chelsea King, is that correct?
Yes.
Okay. And you can hear me all right, Chelsea King?
Yeah.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for a final pretrial.
And is that a fair statement, Mr. Harris?
That is correct, Your Honor. I spoke with Ms. King regarding the case, the allegations, and the police report. At this time, we would be requesting the court set a final pretrial date.
Right, and is that 26 at 8:30?
It is.
All right. All right, Chelsea King, we'll see you on August 26th at 8:30. That'll be live on the 6th floor of City Hall of Lansing for the final pretrial. Anything else for the record in docket 25-01125, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
Chelsea King, do you have any questions of me?
You said that was the 26th at what time?
At 8:30.
Okay, thank you.
You're welcome. That's all for the record in that file. Thank you for your appearance today.
Thank you.
Your Honor, does the court have a file for a Robert Murphy?
No, he is passed.
Understood. I just wanted to make sure. I didn't know if that had,
I included you on the email that I submitted the Nollies on. Pretty sure I did.
I don't have. it, so-
apologies. If I may have been included and may have missed it in the hecticness of preparing for the jury trial last week. I'm not,
It was after the jury trial.
Oh. well, that I may have potentially missed it, Your Honor.
Doesn't-
I just wanted to make sure, as my understanding from Mr. Palmer was that he had passed away.
Yeah, I think I signed that.
I believe there were two nollies because there were two
Right,
files.
and did Ms. Wicks or Mr. Aries, did you need some time to speak with Mr. McGriff?
If he's being arraigned by the
He's
magistrate,
gonna be arraigned at 1:30 by the magistrate.
I believe he would have spoke to Miss Robinson.
They said that, they did not put him on the public defender today because they thought we were arraigning him.
Oh,
Then-
he fell in the cracks of the
Let me see when his
system.
last.
But I'm assuming that since he's got a felony file with us and Jacob Sarts is already his attorney, we'll just get assigned to him. But
Very likely, I will make sure a file gets in for the
Alright.
new. I'll make it happen.
All right, just so Mr. McGriff knows what's going on, and then did you want to call that case?
Yeah, I think if we could.
All right. All right, Mr. McGriff, you can come up here. So we're on the record in docket 25-00829. This is People of the State of Michigan versus Jabril McGriff, set for pretrial and a PA 53 violation. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the People.
And Ms. Wicks. I
Taylor
think
Wicks.
Ms. Wicks. I know it's Mr. Sarts on another file.
Taylor Wicks, Assistant Public Defender, on behalf of Mr. McGriff, who is present and standing to my right.
And sir, you are Jabril McGriff, is that correct? Right, thank you. This is a time set for a pretrial and a contempt hearing in the file. Mrs. L, how we proceed?
Your Honor, at this time, we would be asking for the underlying file to be set for a final pretrial. As for the contempt, Your Honor, we do believe that that is arising out of the new felony file that's making its way through. So we would ask for that to just be set with the final pretrial.
Okay. And is that a fair statement, Ms. Wicks?
It is.
All right, so let's set them both for final pretrial, and we'll set the PA 53 on the same date. And so what date are we using? August 26th at 8:30. And then we'll set the PA 53 for the same date, August 26th at 8:30. And then you can let Ms. Wicks, you can let Mr. Sarts know what happened on the case.
Will do.
Or we used to talk, you can put it on a computer, I'm not sure. Leave notes in the file, what have you.
I will make sure everything is taken care of, and I will make sure Miss Robinson gets in.
All right. Anything else for the record in 25-00829? Mrs. L.
Not for the people.
Ms. Wicks.
No, thank you.
All right, Mr. McGriff, we'll see you on August 26th on this file in the contempt. And then you can get any other information from Mr. Sarts, your attorney, okay?
Yeah.
And I think their magistrate's gonna arraign you about 1:30 on new charges, okay? All right, you should be all set. You know, that's exactly why nobody really wanted to work with Mike Ferenczi in the prosecutor's office.
Your Honor, if we could go ahead and call the Janisha Davis case.
Do me a favor. I think the docket, the second page is on my desk.
Your Honor, actually, if we could call the Henderson case, Mr. Harris would just like a couple more.
All right. Austin Henderson.
Yes, please.
Right, so we're on the record in docket 25-00541. That is People State of Michigan versus Austin Henderson. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
And sir, you are Austin Henderson, is that correct? Correct. Thank you. This is a time set for a sentencing in the matter. And Mrs. L, do you know of any restitution of $170 to Taylor Witherell?
That would be correct, Your Honor.
Can I have a pink sheet for that form? Mr. Henderson, you are not represented by counsel today, is that correct? Correct. So have you had the opportunity to see the pre-sentence report that was filed in this case? Yes. Do you have any additions, deletions, or corrections to that report? No. Allocution, Mr. Henderson, on your behalf, what do you like to say to the court? Did you see the recommendation? Do you believe the court should follow the recommendation? Yes. All right. Mrs. L, any comment concerning Mr. Henderson, the sentencing of Mr. Henderson?
Your Honor, we would ask that the recommendation be followed. Additionally, we would also ask the court to consider a no contact order with Taylor Witherell for the term of the probation. We understand this is not an assaultive case. However, in our communications with Ms. Witherell, she has indicated she does not want to be contacted by Mr. Henderson. So we would ask the court to consider that as well.
All right. So this is for a guilty plea that occurred on June 10th, 2025 to disorderly jostling. It is ordered by the court that the defendant spend 0 days in jail. Credits given for 0 days previously served. We'll set fines and costs, $100 fine, $100 costs for $200. Crime victims' rights fee of $75. State minimum court cost fee of $50. Restitution at $170. And then I'll set on 6 months probation as opposed to the 8 requested. And I'll give you a full amount on that. 200 plus 125, 170. 180. I get a 675. Let me do that again. It's 200 plus 125, 170, 80, 675. All right. Restitution is go to Taylor Witherell in the amount of $170. That'll put you on probation for 6 months. A Zoom is appropriate. Your probation officer will be Nathaniel Nebbs. There'll be a no contact per the 6 month with Taylor Witherell. You can type that in. We'll print this out because this is some differences. And that's to be no contact with the victim, Taylor Witherell, to be within 2,000 feet of where she lives, works, goes to school without consent of the court. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs under your analysis as directed by your probation officer. No bars or nightclubs. Submit to complete following rehabilitative services and pay fees and provide proof of completion to the court. You should submit the moral recognition therapy. I think that's like a weekend, okay? Or an online thing. But you should complete that course and make the certificate available to your probation officer. Not obtain or to obtain and maintain employment, not purchase or possess firearms, ammunition, or weapons of any kind. Do you have any questions of the judgment of sentence, Mr. Anderson?
No, I do not.
All right, I'm going to go ahead and I'll go ahead and wait for the original to be printed out. I know Mr. Neves, he's a pretty easy guy to work with. If you go one floor down all the way to the right, he's going to contact via Zoom for probation. You might want to see what number and get that all set up. See the time he's looking for. But essentially, it's a no contact, 6 months probation with the judgment of sentence. Anything else on the record in 2500541, Mrs. L?
Not for the people.
Mr. Henderson, do you have any questions of me? You should be all set. Thank you for your appearance today. That and the other. Mr. Henderson. All right. Are you ready to proceed on Ms. Davis?
We are, Your Honor.
Yes, Your Honor.
All right, so we're on the record in dockets 2401676. That is People of the State of Michigan versus Janisha Davis. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Davis, who is standing to my right.
And ma'am, you are Janisha Davis, is that correct? Right, thank you. This is the time set for a judgment of sentence or a sentence. Does I have restitution to go to Alyssa Halfman for $891.73?
That's correct.
Okay. Mr. Harris, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor, I have gone over the pre-sentence report. I will note that as to correction, additions, deletions, or corrections, I will note that Ms. Davis has indicated she is now employed working at an Amazon warehouse. She is currently just waiting on her start date now.
All right, with that understanding, I've added that. And then I'll make a note and indicate to see the updated employment data. Anything else? Allocution, Mr. Harris, in regards to Ms. Davis.
Yes, Your Honor, at this point, I would be requesting the court would not follow the recommendation here, Your Honor. I have spoken with Ms. Davis regarding the recommendation regarding this case. She did indicate that she is apologetic for any issues that may have been caused or further exacerbated with probation. To the best, when I was speaking with her, she indicated that to the best of her knowledge, she had not received a notice or proper notice for the originally scheduled interview on June 13th, 2025. To the best of her knowledge, she hadn't received almost any communication from probation, and she had tried to call probation multiple times to try and figure out who her probation officer was, when her meeting was supposed to be, if she was going to be getting a Zoom link. She indicated that when she called, she only ended up getting a voicemail, and so she ended up leaving a message. My understanding is that she was able to get through, from the report, is that she was able to get through and have a report and have an interview originally scheduled for July 28th. During that interview, it seems like there was a bit of an issue my client was having with a press-on nail, where it came off during the interview, and she attempted to ask the probation officer. My understanding is she attempted to ask the probation officer for a moment to essentially put that back on, press that back on, so that she wouldn't have any issues. It seems from my review of the report that there may have been some confusion about it being a press on, and the PO may have thought that the client's actual toenail may have come off, which might have led to the officer describing it as disfigured in the report. My client has indicated there was no disfigurement, blood, injury, or anything, as it was simply a press on toenail, and she was simply trying to just adjust that before continuing with the interview. However, before she could properly communicate that, the interview was cut off by the probation officer, at which point the report we have here was drafted. We'll also note that regarding any concerns of agitation or rudeness that Miss Davis may have displayed in that brief interview she had, Miss Davis does apologize. She indicates that she is going through a very stressful period at this point. She's a very young mother who is currently going through a separate family court case involving custody of her child. My understanding from her is that as a result of that case, she's already currently being drug tested. She's already participating in counseling, group therapy and support groups. She's already, as well as she's seeing a therapist. I will note that, Your Honor, it seems to me like this is a young woman who is struggling with numerous things, and I believe that probation could potentially be extremely beneficial for her to provide her with some sort of structure and some sort of additional programming that could help her manage these stressors in her life in a more productive and healthy way. At this point, I would ask if the court would perhaps consider one final attempt to get the interview done. What I will note is apparently, from my review of the report, there was the first original interview that was missed, for which my client claimed she didn't have notice, and then one interview that was unable to be fully completed, likely due to that misunderstanding and the issue with the toenail. At this point, Your Honor, I believe I honestly, in my opinion, Your Honor, I've seen cases come through here that have had far more issues with appearing, or far more issues with meeting dates, that have still been able to work things out and organize things with probation. So I believe that there is still a chance and I believe that Miss Davis is more than willing and more than able to complete a term of probation and would be willing to abide by any terms that the court would order. So I would request that the court would consider setting this out one final time to allow her to have that interview, if possible. If the court is not interested in, one last thing I will note on that front, Your Honor, is that as far as it seems to me, is that Miss Davis currently has a decent amount of structure in her life. She's managed to get a good job. She is, as part of the family court, for which she's currently doing drug testing, counseling, therapy, programming, she's managing to get he's managing to get any issues with substance abuse that the probation officer did mention in the report under control and indicated those would no longer be an issue here. So I believe that at this point, any potential jail sentence would likely compromise the progress Miss Davis has currently made here towards her family court case and towards getting a job, towards becoming a more healthy, productive member of society. So I would be requesting that the court would consider one final chance to let her prove to the court that she can do probation, that she can succeed in probation, that she can get the PSI done, Your Honor. I have spoken with her and I have stressed with her the importance of being in touch with probation and properly discussing with probation if there are any issues or if anything needs to be rescheduled or reorganized based on either party's schedule. And I believe that if given the chance, Miss Davis would absolutely prove that she can succeed on probation. If the court is unwilling to give her that chance on probation, Your Honor, I would ask if the court would perhaps consider some other non-jail, non-probation sentence under MCL 769.5 Section 3. I understand that since this is a non-serious misdemeanor, there would be that rebuttable presumption of a non-jail, non-probation sentence. If the court would be rebutting that presumption, I understand the court can do so with a finding of good cause, but I would ask the court to consider that. Finally, Your Honor, regarding if the court is inclined to enter any potential jail sentence here, I would ask that the court consider perhaps a lower sentence other than the 60 days recommended, as that seems rather excessive to me, or perhaps request that the court consider allowing her to do that sentence on weekends, or allowing her to do that sentence in some way that would not compromise the progress she has made with her family court case, with her programming and therapy, and not compromise her the job she has just recently managed to obtain, Your Honor. And beyond that, the only final arguments I would have to make is regarding fines and costs. I will note that there is the restitution payment here. And so I would ask if the court is going to move forward with the sentence today, that the court consider waiving or otherwise reducing any fines and costs the court orders, so that she can possibly, so that my client can focus her limited resources towards that restitution payment and towards any programming she has with family court and any potential programming she may have here, if the court is willing to entertain my plea for mercy to allow her one last chance to have probation, Your Honor. Thank you.
Thank you. I don't think I've ever done this before. Shall we, I'm going to speak with both counsel and chambers.
Thank you, Your Honor.
All rise.
I don't think I've ever done.
Yeah. There's usually some right there. I didn't know it was gonna squirt like that, my bad.
No, we were here last time and she produced some bank records, they never got to me, 2:03 today at fax when we arrived, for the 2 o'clock hearing. And that time to review the bank records, I'm going further questions, once I have an opportunity to review the bank records. We get, a date, to continue this examination, so I have an opportunity to review the bank records. So, I appreciate that. Thank you so much. September 4th, 10 a.m. Thank you very much. Yeah. We also have a Matthew Lion. For those two. You don't have anyone for your show cause with the name to the address and the original. Okay, thank you, guys.
All right.
Right, you can be seated. We're back on the record in docket 24-01676. And we had spoken about adjourning this sentencing. Mr. Harris, a response to that.
Yes, Your Honor, I have spoken with my client regarding that potential adjournment of the sentencing. She indicates that she is completely aware, completely understands, and we would not be objecting to any kind of adjournment of sentencing, and would also be requesting the court consider adjourning sentencing for the reasons that were discussed in chambers.
All right, Mrs. L.
Thank you, Your Honor. That's our understanding as well. We have no objection to adjourning for this.
All right, I think as part of sentencing, we have, we have all further a little bit more to dig into. I'll get a date for the future sentencing. Yeah, how far out are we looking?
I would say at least 3 weeks to give us an opportunity to look into everything.
I think 3 weeks is fair. I just don't know what's available.
3 weeks is a date that is set for jury trial, so we don't have very much availability on that day.
That would be
August 26th.
August 26th.
Is
How about 4 weeks?
the court is not available.
And I think 2 weeks is too fast.
I can do 5 weeks, which is I believe September 9th.
9. Would 5 weeks suffice? In the meantime, if if Ms. Davis does need to go back to probation, that might work in some time to do so. All right, because we could have an updated report from probation after 5 weeks. So let's do that. We'll do September 9th at
1:30.
1:30. Ms. Davis, you've waived no rights in this matter. And then I'll wait to hear from the parties, and you can let us know if she needs to go back to probation. We can help set that up for an updated report. All right.
Confirm, Your Honor, regarding the updated report, would that be something she could go down now to
I
set
don't.
up or?
I think I'm waiting to hear from Mrs. Zell to see if we need to.
Understood.
If we need to go through that process. It's out there and we know of it, but I'll let the parties look into it a little bit more. All right. Anything else for the record in 24-01676, Mrs. Zell?
Not for the people.
Mr. Harris.
Not for the defense, Your Honor.
All right, Ms. Davis, we'll see you back here unless I hear differently from the parties on September 9th at 1:30. All right, ma'am? All right, thank you.
Yes, well, thank you. You guys have a great day.
You too.
To the best of my knowledge, Your Honor, my other sentencing, Nicole Fitzgerald, has not appeared in person. And
I don't think any of her
believe she's on Zoom.
Do we have nobody's on Zoom or any of the arraignments here?
Yes, Mrs.
All right.
Dumond is here.
Let's go ahead and let's call that your last sentencing, because I think we're almost an hour into it. So that's Ms. Demond. I'm sorry, that is Ms. Fitzgerald. All right. Right, so we're on the record in docket 25-01117. That is people of the state of Michigan versus Nicole Lynn Fitzgerald. Appearances for the record, Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Nicole Fitzgerald, who unfortunately does not seem to be here in person or via Zoom, Your Honor. I did try and get in contact with her via email yesterday with a courtesy reminder of the court date and a copy of the PSI and a request that she get in contact with me if she had any questions or wished to discuss it. I never received a response to that email. When I did not see her here by around, I think it was 1:38 this afternoon, I tried contacting her via the phone number we had on file, and that phone number, and I was advised that phone number is unable to receive calls at this time. So I was unable to leave any kind of message or request any kind of callback. At this point, I do not have any explanation for the failure to appear. Your Honor.
All right, this was scheduled the sentencing was scheduled for 1:30. It is now 2:22. I do not see Ms. Fitzgerald in the Zoom courtroom. There's nobody by that name in the physical courtroom. I don't think there's anybody in the hallway. I think Megan was just in the hallway. And so, so it appears that Ms. Fitzgerald has failed to appear for sentencing today. She was given this date on June 3rd, August 5th at 1:30. And then based on counsel's representations, it appears there was some follow-up that was attempted to be, and she was not able to be, any contact was unsuccessful. Ms. Zell, how would you like to proceed?
Your Honor, this is Ms. Fitzgerald's first failure to appear. However, based on the defense's indication that they have not been able to successfully contact her, we would ask for a bench warrant with a 48-hour hold. We wouldn't have any objection to a courtesy reset if the court is so inclined. However, we do think that without the communication there, it might be harder to get.
Yeah, I think there's been an attempt by her attorneys to reach her, and she was given notice of this. So it can be a miscommunication. I will set a bench warrant for the failure to appear for sentencing. Ms. Fitzgerald, I'll set a bench warrant, but we'll place it with a 48-hour hold just in case counsel's able to contact Ms. Fitzgerald. Anything else for the record in 25-01117, Mrs. Zell?
Not for the people.
Mr. Harris.
Not from the defense.
All right, we should be all set. Thank you for your appearance today.
Your Honor.
Thank you, Mr. Harris.
I guess I will stick around in case anything is needed regarding those PDs.
All right. Is it Ms. Demond? I think you're not here on the arraignments.
Not usually.
All right.
If you need me, I can stick.
No, I
around.
think we're good. Mr. Harris, we might need, he might need to, depending on what we do with Ms. Demond. All right. So we're on the record in docket 24-03213. That is people of the state of Michigan versus Patricia Demond. And ma'am, you are Patricia Demond, is that correct?
Yes,
Correct?
Your Honor.
All right, thank you. This is the time set for probation violation arraignment. And it is alleged by Jody Bayless on July 28, 2025. The following allegations have been made against you: that you violated your probation in a non-technical format by having contact with the victim on July 24th and July 25th, engaging in assaultive or threatening behavior, and placing the victim, I'm assuming it just says place the victim in reasonable fear or bodily harm, which would be part of the no contact order. I don't know. But do you understand the nature of the allegations that have been brought against you by your probation agent?
Yes, Your Honor.
You have several rights in this matter, and I'm going to walk you through those rights. You have the right to a hearing. You have the right to be represented by counsel, which you probably should be represented by counsel. Mr. Harris from the Public Defender's Office, I see that you were previously represented by the Public Defender's Office on this file, on the underlying file. Is that correct?
Yes, Your Honor.
All right. So let's do this. It works differently. Usually we have an arraignment and then you have to indicate whether you're going to be represented. Mr. Harris is here from the Public Defender's Office. You can speak to him and make application right now. And then I'm going to reset it. I'm going to set it for formal hearing. And he's one of two public defenders who are assigned to this courtroom. So that would, that'll provide some transition, some similarity in transition as Mr. Ned and Mr. Harris are assigned to the case. Is that how you'd like to proceed, ma'am?
Yes, please.
All right, so I'm gonna have you're going to talk and make application to the PD's office. And then we're gonna reset for formal hearing. And when is it reset for?
August 14th at 8:30.
August 14th at 8:30. And Mr. Harris is right here and has that date. So I would make application, and then we'll see you again on August 14th at 8:30 for the formal hearing. All right, ma'am?
Thank you, Your Honor.
All right. Anything else for the record in 24-03213? Are you all set, Mr. Martin?
Yes, thank you.
All right, thank you.
Not too shabby.
And then I don't think anybody else showed up for it. We can't get anybody to play with us. Is Cameron Carter still incarcerated?
He was supposed to be writ over.
From where?
I want to say Eaton. I actually don't know if he's here or not.
Let's see.
He could be downstairs. He is writ from Wayne County.
From Wayne.
allegedly.
Yeah, we read him from Wayne on July 16th. So Megan, you can go see where Mr. Carter is. And then I don't think Chase Flores is here.
Probably call that one.
So let's call that. And then we can call some civil cases. Are you here from the Smith Law Firm?
I think so. Yes.
Two discovery hearings?
Just one for me, I believe, just Roberto Galvez Campos.
Yes, the other one, 12th one was this.
Okay, we have Campos. We also have Doherty.
Oh,
Do you have Doherty on your?
I do not. They just sent me the one today.
All right. And then, all right, so let's wait for Mr. Campos.
Yeah, I'll check out in the hall.
All right, and then
Oh, it's just.
it's a 2:30, so you're a minute early, which makes you on time.
Yeah, right. So.
Yeah, exactly.
At least you know I'm here.
Yes.
I'll be back.
All right, so we're on the record in 24-02-851. That is people of the state of Michigan versus Chase Flores. This was set for 2:30. I'm sorry, this is set for 1:30. It is now 2:30. And it appears the defendant failed to appear for the probation violation arraignment. I do not see Chase Flores in the Zoom courtroom or physical courtroom, and there was nobody by that name in the hallway. There seems to be a positive recommendation in this matter. And how old is Mr. Flores? All right, so this was set for 1:30. It's now 2:30. It appears the defendant failed to appear today for the probation violation arraignment, and the court will issue a bench warrant for non-appearance. And that's all for the record in 24-02-851.
Carter, Cameron Carter is downstairs, so maybe she'll be able to bring him up.
All right. And then Mr. Dowrick, you're here on this is Kira Wilkie's case.
Yes, sir.
Oh, and she's here. She's on. This is set for pre-trial today. Let me pull that case up. And then Ms. Wilkie, I'm gonna have you unmute. And we'll
Hello.
call your case. So we're on the record in docket 25-01492. That is Kira Wilkie versus Todd Dowrick. Appearances for the record, Ms. Wilkie. You are Kira Wilkie?
Yes.
All right. And you can hear me all right, Ms. Wilkie?
Yes.
All right. And then you are Todd Dowrick.
Yes.
All right, thank you. This time set for a pretrial in the matter. Let's see. And this is I have this set for a pretrial on the matter. Usually I give the parties a chance to discuss the legal issue together if they choose to. If during pretrial, neither party is represented by counsel, so we can actually do a pretrial order setting I think we're just setting timeframes. You know, like when we can do discovery, what we hold on to, what we're not holding on to. Ms. Wilkie, would you like the opportunity to speak with Mr. Dowrick, or do you just want us to go through and fill out a pretrial with the understanding that I'll explain the pretrial to you, and then you can decide whether you want to come in and sign it or whether you want to sign it via Zoom.
Okay.
So which would you prefer? Do you want the opportunity to speak with Mr. Dowrick, and then we can come on, or do you want to just fill out the pretrial statement?
Fill out the pretrial statement.
All right. All right. So the pretrial statement is on case number 25-01492. A pretrial conference was held on August 5th, 2025. Both the plaintiff and the defendant were in pro per. We've done a kind of this as for a legal issue, which we headed up. We usually put breach of contract. I don't know if that's a part of what's going on here. Ms. Wilkie, you're the plaintiff. So what was the allegation, the legal allegation that led to the filing of the complaint?
A false eviction on my name, and also causing homelessness and severe emotional distress.
So what's the tort?
Homelessness. So it's the charges for that. I'm looking to get my charges up, the funds back to me, reinstated.
All right, so some type of breach of contract.
Yep, from a breach of contract from a previous lease.
Your Honor, Ms. Wilkie was a Section 8 recipient. She turned in a 30-day notice to vacate. Then she moved out at the end of her lease. She was not evicted. She was welcome to stay. We would have renewed her lease.
So she was under a breach of contract for non-payment.
No, she was not, because the rent was paid by Section 8.
All right.
She turned in a 30-day notice to move. She moved out. She chose to move. She moved out on the last day of her lease. The property was a Section 8 property, meaning it was inspected before she moved in and approved. City of Lansing inspected property. The property was habitable. She chose to move out, and she's saying she was illegally evicted.
All right, so we'll place the legal issues of breach of contract. Ms. Wilkie, do you anticipate any further pleadings in this matter?
No.
Mr. Dowrick, on behalf of the defendant, do you anticipate filing anything? We're going to hold back on a motion for summary disposition, which is kind of what you're doing now. You're indicating legally there's no reason to go forward. We're going to hold back on that till after discovery.
Okay.
All right. So I will put NA for non-anticipated, and then the motions we're holding back on a motion for summary disposition and the response if it occurs. I'm going to indicate that this is not to be consolidated with any other case. The admission of facts are not applicable. Exhibits are not applicable. We've set discovery for November 3rd, 2025. So your discovery is November, 90 days for discovery till November 3rd, 2025. Expert witnesses are not applicable till after discovery. Damages not applicable because they were pled for. I'm assuming they were pled for in the plaintiff's complaint. And then joinder of claims. Ms. Wilkie, you have not paid for a jury trial in this matter. I have it as a bench trial. Have you paid for a jury trial in this matter?
No.
Mr. Dowrick, have you paid for a jury trial?
I have not. No.
All right. So we'll leave it at bench. I'm going to indicate the negotiations are ongoing. Do you see any reason that we would mediate or place this case for case evaluation, Mr. Dowrick?
Your Honor, I did prepare a pretrial statement. Would you like that?
Let's fill this out, and then but I may have you look at this to sign it, okay?
Yes.
Because I'll need it for both parties to sign it since she's the moving party.
Okay.
Do you see any reason for mediation or evaluation?
I see on this form, I say that the defendant is willing to go to mediation.
Okay.
I feel that it's a completely nothing case.
Right.
but I am open to mediation.
I'm gonna set for case evaluation. I just don't see it legally. Mediation, I'll put yes, at the parties. So if you choose to, mediation will only take you if you choose to go there. So Ms. Wilkie, that would be an independent mediator to look at the facts of the case and see what's at hand. I placed yes. I'm the only one who can set that. So if you come back and would you be agreeable to mediation or not at this time, Ms. Wilkie?
Not at this time.
Okay. So I'm not going to set it. I'm not going to set for mediation. So the only thing we've done at the pretrial statement is kind of a scheduling. We've scheduled this. I don't want to put anything down for pleadings, admission of fact, exhibit, expert witness, damages, or joinder of claims because you've not completed your discovery. All that usually comes after discovery. Discovery is set. The cutoff date is November 3rd, 2025. Neither party has asked for a jury trial. Negotiations are ongoing. Ms. Wilkie, do I have your permission to sign this via Zoom? And then you'll get a copy of the pretrial statement. I don't know if you can see it up here, but that's what I'm holding up is the pretrial statement. I get permission for you to sign it, and Mr. Dowrick to sign it. Or you can come in and sign it. It's entirely up to you.
What does it say on it? Because I can't read it from you, obviously.
Everything. The only thing we've really placed is we're holding back on the motion for summary disposition, which would be a legal motion that you have not brought a legal claim. And then we've set discovery to November 3rd, 2025, which is that's the time permitted for each party to get any information they want concerning the trying of their case. That would be 90 days out, which is the usual amount of time, November 3rd.
Can we do before? Why? I don't need 90 days. So can we do that earlier than that?
It's really, you can ask for it to be less than 90 days, but that's the usual standard time when you file a complaint. And that's what you've done in this. You filed a complaint.
It could be less than 90 days. I don't need 90 days.
Mr. Dowrick, it can be less than that. It can be 90 days. I've set it at 90 days, so.
90 days is good.
Okay, we'll set it November 3rd, 2025, the 90-day time. I'm doing that because you're not represented by counsel, and you may take more time than necessary to get your 3 months done. Because this is your complaint. This is you're the moving party in this, Ms. Wilkie.
Correct, and I don't need 90 days.
All right. Well, you've got 90 days if you need it. Mr. Dowrick, may I sign this via Zoom on your behalf? And you certainly can look at this if you want to. Okay. And then, Ms. Wilkie, if you don't want to sign this via Zoom, we can have it at the civil department, and you can sign it there, or you can come to our office and sign it.
Okay, I'll come in and sign.
All right.
Your Honor, I mailed my answer to Miss Wilkie, and it came back from the post office. We mailed it to the address that she gave us.
All right, so that's the start of discovery. What is your correct contact email? Please provide that to Mr. Dowrick so he can email you an answer, or else he has no idea where to send the paperwork to, as it came back as undeliverable.
First and last name at iCloud.com.
Well, yeah, but you've got to give him an actual address so he can mail it.
You can do 1609.
1609.
South Martin Luther King.
Martin Luther King.
Jackson, Michigan.
Michigan.
Yep, 49203.
49203. Do you want that as the new address, the new updated address for the court file?
Yeah, that's fine.
All right, yes. All right, and just so there's no misunderstanding, everything we're saying now is on the record, so it's all being recorded. All right, so Miss Wilkie indicates that she will sign the document in person. Mr. Dowrick has signed the document. I will await for Miss Wilkie's signature on this before I sign the document. And so Miss Wilkie, you should be in by the end of the week. What we're gonna do is we'll give this to the civil department and have you come in and look at it and sign it. All right, ma'am?
Okay.
All right. Anything else for the record in 25-01492, Mr. Dowrick?
I just want to make sure I understand, Your Honor. So discovery is through November 3rd.
Correct.
And that's for each of us to gather information
Concerning this file.
For ourselves, not to be shared with the other party.
You have to share it with the other party. There are no surprises. So if she wants any information, Miss Wilkie should set up a list and provide it to you, and you can do the same to Miss Wilkie. Set up a list having to do with this file.
Okay.
It's set for November 3rd, and then after November 3rd, if you want to file a motion for summary disposition indicating that there's no law that would provide any access for the plaintiff's argument, you can indicate that as a matter of law, Ms. Wilkie has not made her claim. Ms. Wilkie can also file a response to that. That would be heard after November 3rd.
Okay, so that would be filed after November
Yeah,
3rd.
filed after November 3rd.
Okay.
Just to keep it clean, so you'd have discovery first.
Okay. All right. I think I understand a little better. Thank you.
All right. And then if you have any questions, contact the civil department.
Oh, one last question, Your Honor. So the information that I share with Miss Wilkie, do I also share it with the court?
Only during that discovery process, only with Miss Wilkie, but there has to be a nexus to why you're sharing the information on this file.
Okay.
So you just can't ask for anything. Yeah, it's got to be in regard to this file.
Okay.
Right. All right. Miss Wilkie, do you have any questions of me?
Not at this time.
All right. So I will set discovery for November 3rd right now. Thank you, everybody, for your appearance. And then we will take this to the civil department because I won't sign it until Miss Wilkie signs it.
Okay.
All right. You're all set, Mr. Dowrick. Thank you. You're all set, Miss Wilkie. on the Samsung, could you please identify yourself? I have you, Mr. Rusin. On the Samsung, could you identify? You are Philip Herrera?
This is Phil.
Yeah, you probably can turn off your video and we might be able to hear you better.
Okay.
So if you close down your video, but you are Philip Herrera, is that correct?
Yes, sir.
Okay. Let's, you are Johnny on the spot there. All right, let me start this. All right, so we're on the record in docket 2400258. That is LVNB funding versus Philip Herrera. Appearances for the record, Mr. Rusin.
Thank you, Judge. May it please court, I'm attorney Richard Rusin. My bar number is 35222. I'm the attorney of record for the plaintiff, and today I'm also the respondent to defendant's motion to set aside a garnishment.
All right, thank you. And sir, you are Philip Herrera, is that correct?
That is correct.
All right, this is the time set for a motion to set aside a garnishment that's being objected, or that, I don't know, Mr. Rusin, did you want the opportunity to speak with Mr. Herrera based on his motion before the motion, or do you want to go forward responding to the motion? It's entirely up to you.
Well, it doesn't matter to me, Judge. Like my partner Paul Varchetti says, it doesn't cost anything to talk. I was reviewing the restorative actions here. I'll be delighted to go into the breakout room. We can do something great. If not, I'll let you be the judge. We'll go back on the record.
All right. All right, Mr. Herrera, would you like the opportunity to speak with Mr. Rusin, or do you want to go forward with the case?
We could go forward. I think I really don't
right.
have any knowledge of this. So.
All right, Mr. Herrera, we're here on your motion. So why do you? So tell me what the sum and substance of your motion is.
Well, like I said before, I don't have any knowledge of this amount, the amount owed. I don't know what. Don't recall ever having an account open with.
So your motion indicates that you think they have sued the wrong person.
There is a possibility. I have had issues with identity in the past.
Do you have any paperwork indicating that you have been under investigation as the person who has filed a false police report or false identity in regard to this situation?
I don't have any documentation like that. The only thing that I can obtain is information, Social Security. I have received something else from where they list benefits, and there is a period
Mr. Herrera, you're breaking up. You're breaking up, so I can kind of hear you. I kind of cannot.
Okay. So bottom line is I don't have any documentation like that.
All right. So the indication is today that you don't know why your name is being sued on in regards to this 24-00258?
That is correct.
All right, Mr. Rusin, why don't you enlighten Mr. Herrera about the nature of the lawsuit and any response you have?
Judge, I'm going to move backward in time in a crab-like motion. This is going to be about a 3-minute oral argument.
Okay.
Judge, we are here today on a motion filed by defendant. The motion is filed not in compliance with the court rules. And that in Mr. Herrera's motion to quote, set aside garnishment to be stricken under MCR 2.115 for not being drawn in compliance with the court rules. Why do I say that? Because if Mr. Herrera had filed an objection to the wage garnishment, which is provided under MCR 3.101, by which the garnishment process was filed, then we would look at the grounds under MCR 3.101, I believe it's N, that would be used to successfully prevail against a garnishment. But he didn't do that. He filed a motion. That's not allowed under the court rules. Now, let's go further and say, why did the garnishment issue? The garnishment issued based on a judgment for Mr. Herrera's failure to appear at a pretrial conference with Your Honor, May 23rd of 2024. Yes, I said 2024, not 2025. No. So we've gone over a year with the default judgment entered for Mr. Herrera's failure to appear at your pretrial of May 23rd, 2024. My appearance counsel appeared there. Mr. Herrera did not. I noticed from the notice to appear from the clerk's office that Mr. Herrera was given notice to appear at your May 23rd, 2024 pretrial at the same Fielding Drive address which he used on his present motion. Did he have notice to appear to your pretrial? Yes. Yes, he did. What did the pretrial notice say? It says, important, read this carefully. Number 3, failure of the defendant to appear in a civil case may cause a default judgment to be entered. That's what happened here. What happened next? Well, the judgment was entered. I'm looking at a copy, a true copy, Your Honor. You entered, you entered a default judgment against Mr. Herrera, May 29th of 2024. What happened then? My office mailed him a copy. There's a proof of service filed in the Register of Actions by my clerk, Anna Montesoros Soso, that June 6th of 2024, she mailed a copy of the default judgment to Mr. Herrera, again on the Fielding Drive address. What did he do? Nothing. Did he move to set aside the default judgment under MCR 2.603D? No. No, he did not. More than 21 days has gone by since that default judgment under MCR 2.603D. And in fact, more than 12 months has now gone by since that default judgment was entered by Your Honor. And pursuant to MCR 2.612, Mr. Herrera be time barred statutorily from filing a motion to set aside default judgment. Now let's go forward further. Mr. Herrera filed an answer to the complaint. I'm just reviewing a copy. And the answer to complaint was filed. And he alleged the same thing in his answer to complaint that he's alleging now in this motion not drawn conformity with the Michigan court rules under MCR 2.115. And he's asking for the same thing that he said in his answer, which would have been heard a little louder if he would have appeared at the pretrial conducted May 23rd of 2024. Then let's go forward then to the original complaint. My client retained me on behalf of LVNB Funding as an assigned debt for WebBank. Apparently, in one time, Mr. Herrera on October 8th of 2019 obtained a loan through WebBank. Payments were made, and then the last payment were made was May 8th of 2021. All the loan and all the payments originating from the Fielding Drive address. So then after payment default, May 8th, 2021, the bank was WebBank, closed it pursuant to applicable FDIC rules. charged it off, and it was assigned to LBNB funding to collect the balance of the unpaid loan from Wedbank, which was filed in the amount of $4,180.51. In summary, this motion should be denied. It is not drafted in compliance with the Michigan court rules. And if anything was filed by Mr. Ferrer after default judgment, the case would have proceeded a little differently. But now you can't, Mr. Ferrer can't come back more than 12 months after the default judgment and say, I don't know anything about this. And then I rest.
All right, thank you. A response, Mr. Herrera.
I honestly don't say this. I may have received mail during that time, but I wasn't in the house.
Mr. Herrera, you're breaking up. You're breaking up. So you're gonna have to speak slower.
Can you hear me?
Yes, I can.
This account. There may have been material mailed out to me regarding this over a year ago, but head of this household, and I never checked the mail on my own. So there may have been many times where I didn't get any notification.
Okay, your indication is that you may have not gotten the mail to your last known address, to the correct address. Is that correct? Is that a yes or no? And Mr. Herrera, we can't hear you now. I can't hear you at all now.
Yes.
Is that a yes or no, Mr. Herrera?
Yes.
Okay.
That's yes.
Thank you. Okay, thank you. I'm going to deny the motion to set aside, deny the motion at this time. And Mr. Rusin, you'll follow it up with an order based on the record you've made and based on what the motion is denied based on what's been found on the record, which is truly based on the motion you've made, that this is not only time barred and late, but the adequate steps we're not prepared to object to the garnishment, and the motion did not take the proper procedure under the court rules. You'll follow that up with a motion, Mr. Rosen?
I will file the order to comply with the ruling of the court today, Your Honor. Thank you very much.
All right,
I'll submit
thank
it
you.
by Sunday rule.
All right, thank you. All right, Mr. Herrera, you're all set. Thank you for your appearance today.
Thank you, Judge.
You're welcome, Mr. Rusin.